Good morning.
Hey, Judge, how are you?
I'm doing well enough, I guess.
Did y'all get much rain last night?
A ton.
We only got about an inch at the house. Now it rained in Houston though, because we were downtown Houston last night. It flooded down there.
So, Sherry, I have received a lot of pretrial motions that are
Yes,
going
sir.
to take some time,
Okay.
and I'm going to discuss it with the lawyers this morning. But could you give me some more time in addition to January the 6th, like the day before, perhaps?
Sure. We can January 5th if that's what you want to do.
I'm thinking I need at least 2 days.
Okay.
I'd rather have more than I need.
Okay. So let me ask you another question. Do you want to do that by Zoom too?
Well, that's a good question that I'll discuss with the lawyers.
Okay.
Now I know that some of these witnesses are probably going to be appearing by Zoom
Yes, sir.
at the hearing, in January.
Okay.
So I'm wondering what the best way to do that mechanically is. Would it be simply for us to all use our own laptop computers using the internet access at the courthouse? And if we do that, is it possible for us to broadcast that onto the large screen in the courtroom?
Yes, sir. I think we can do that. It might be easier, for Sherry and I also, because we can use the large courtroom up there.
All right. So in order to do that, is it better that you provide the link, or
Oh, you can do it, Judge.
Does it make any
just
difference?
kick in. Mm-hmm.
I'm sorry, I didn't understand your response.
Oh, we can just kick in from there up in the large courtroom.
Sherry, I think you've got two input devices going because there's an echo.
Hang on.
You have the cell phone as well as the computer going.
How about now?
Much better.
Can you hear me okay?
I think that's better.
Okay. Are you getting feedback from me?
I was getting feedback, yes.
Okay. But you're better now?
Yes.
Okay. But we can do it from the large courtroom if that's what you want to do.
Okay. What was your intention as far as a courtroom originally, until we started having this conversation?
So what we can do, Judge, we can get up on the big screen, and therefore Sherry can see everybody there.
You're referring to the reporter?
Yes, sir. Jill's going to be our reporter today because Sherry actually had a doctor's appointment she couldn't change.
Right.
But Sherry will be here.
Well, in order for each of us to be broadcast, we're going to have a webcam in front of us, which I assume is going to be
courtroom.
One,
We've got two in the courtroom.
I think so.
Yes, sir. We've got two in the courtroom.
well, we're going to have at least 3 stations, you know. You're going to have the applicant's lawyers, you're going to have the state's lawyers, you're going to have me. So you don't have to figure that out today. It's something to be brainstormed.
Okay. I'll go up there this afternoon and I kind of look and see what's what.
As far as I'm concerned, I'm perfectly happy just to set it up on each person's laptop with me initiating the Zoom link, but I don't know how that accomplishes broadcasting it to the screen, or if we even need to have the screen, because observers in the courtroom are perfectly capable of seeing our faces live and in person.
Yes, sir.
And again, this is only for the witnesses that are going to come by Zoom anyhow.
Okay.
I think the parties were ordered to inform us. Yep, in the pretrial order in September, it says no, that's something else. Okay, in their disclosure of witnesses, they're required to disclose whether the witness will testify in person or by remote electronic means, describing the means. So we should know an update on that no later than the 5th or the 6th.
Okay.
Let me just try.
Thank you both for being here early, by the way.
You can hear him.
Can I hear?
See if you can hear him.
Judge, can you speak in now?
Is he speaking? Wait, we gotta plug you. Oh, I did plug him. But you can't hear him? Yeah. Okay. Judge, are you there?
Can you hear us, Judge?
Yes, I can.
Okay.
Okay.
Good.
We tried something different.
I just need to make sure that I want to plug this into here. I think that will help me.
Okay.
Are you good? Are you still here? Okay. Let's see if that works. Yeah, that's good. That works.
Can you hear me? Judge, can you hear me?
Yes. Not very well, but I can hear you.
Oh, you think that's my fault? Okay. Well, shoot. Maybe I just need to log into Zoom. It's
Hold
a,
on 1 second, Judge. I don't know why it did that.
what's it doing?
I can't hear him at all.
Okay. Well, then we just need to go back. It'll be fine. I don't want to panic. Back to where we were. Okay, we're back. We're back. Wait a minute. Oh, this is. Oh, this is gonna be worth the darn now.
Can you hear me, Judge?
Yes.
Can you hear him?
Can't hear you. Can't hear
Okay, great. Right.
you.
Can you not hear me?
Well, you're not plugged in, Sherry.
I
Oh.
was trying to do something else.
Okay. Okay. All right.
There we go.
Probably works better now.
Yes. Perfect. Okay.
All right. So much for that.
Did y'all have a Merry Christmas?
Had COVID,
Oh, no.
So,
both of us.
well, I'm sorry to hear that.
Got over it mostly. How about over there?
All is good here. Found out yesterday I'm going to be a grandma, so I'm excited.
Your very first?
My very first, yes. So due September 7th was the due date, and I think she'll have it a little early.
Your son's child or your,
My daughter, she's my
Your daughter.
oldest. Yes.
where do they live?
They live down in West Columbia. And he works for Dow Chemical. And they've been trying for about 3 years. So we're pretty excited.
When we had our first granddaughter 16 years ago, my wife suggested that we start making contributions to a college fund. So I said, sounds like a good idea. So we had a automatic draft set up to siphon some money out of a checking account, transfer it to a 529 account. And that's increased to the point now where we can probably pay for at least a year's college for that little girl.
It's amazing how everything has gone up.
Yeah. The state has over time shifted the cost of higher education onto families and taken on less and less of the burden themselves.
Agreed. Ms. Bartiz coming down here from the district clerk's office also.
So Sherry, you have that rebound or
The reverb.
the reverb.
Okay.
Yeah, thank you.
No, you're not.
Is that? How about now?
That's better. It shouldn't be a problem since you're not going to be having that much of a speaking role here.
I'm gonna just mute it out.
Morning, Your Honor. Good morning, everyone.
Good morning, Mr. Fuller.
That's working. Judge Delaney,
Yes,
we're gonna do something right quick. Just don't pay any attention to it. We're going to a different computer. Okay?
very well.
You can probably. Let's see.
Good morning, Your Honor.
Good morning. All right, Ms. Vendel, I see you and I see Mr. Fuller. Are you waiting for anybody else to join us?
No, Your Honor, everyone's here from the state side.
And I believe everyone is here from Mr. Falk's side as well. We do have a couple additional attorneys. I think there are some of the attorneys that entered in Pro Hoc VJ, but they are some of the attorneys from the Covington firm. And in fact, this morning, Mr. Bruno Campos will be doing the argument. I won't be doing the argument on this motion this morning.
So good morning, Mr. Campos. You are on the East Coast of the United States today. We can't hear you, sir. You're not muted.
Can you hear?
I mean, I can hear it in my hearing aids. Thank God for old age. Did you need the number? I could have. It's all set. No matter what. No.
Your Honor, just a brief indulgence. I mean, so Mr. Campos,
This meeting is
Excuse-
being recorded.
based
Well,
on
that's good and
the
loud.
East Coast, but he is today in the West Coast for the holiday, so it's not in his usual office. So if you could just please bear with us. Apologize for the delay.
I have to if I can hear that, I'm gonna have to turn my hearing aids off. That'll be
This meeting is being recorded.
too much going on. Too much hearing. This is a little bit of lag.
Sherry, you may need to mute your device.
Your Honor. I've dialed in the audio.
I can hear you now, Mr. Campos.
Yeah.
From
Thanks,
your,
sir. I'm sorry about this. This is,
828
828
302
not fair.
696 62.
Ms. Driscoll, I don't know where you're located. If you're there in the office in the courthouse.
Yes, sir.
Sherry, I can see you on the screen now. I think you need to mute, please.
So we're just back to where we were.
All right, Sherry, I've got two windows for you. One is muted, one is not.
I can hear you, Judge.
What I'm trying to
Okay.
suggest to you is that I don't want to be hearing you
Oh, you won't. I'm
unless
thinking
I call on you for something.
so.
The background conversation is audible to us.
Hold on one second.
You appear to be signed in on two different devices.
Yeah, I was trying to do Judges because he has a speaker and it won't let me do it. So let me go fix that, okay? Hold on.
So you're logged in on that one?
I don't know.
All right, everyone, I think we're at a position where we can begin the hearing. Ms. Driscoll, court reporter for this morning, are you ready?
I'm muted. Hold on. Oh, yes, Judge, I'm ready.
Very well. This is case number 27,347. The writ of habeas corpus number being 18,081-04 out of the 278th District Court of Walker County, Texas. This morning, we are assembled to consider the state's motion to quash subpoenas. I'm sorry, the applicant's motion to quash subpoenas and the state's motion to enforce the subpoenas. And I think I'd like to get announcements of the attorneys who plan to participate for purposes of this record. Mr. Bruno Campos, is it correct that you'll be representing the applicant this morning?
That's correct, Your Honor.
And for the state of Texas, Ms. Vendel?
Correct, Your Honor.
Very well. Before we dive into the substantive matters that we have to deal with, there's a scheduling issue that I'd like to pose, and this will probably involve everybody. We're aware that there seems to be quite a few pretrial motions that have been filed, and that we have up until this point assigned one day, January the 6th, for a pretrial hearing. So I raised the question to you whether you think it would be sensible to assign 2 days, to begin on an earlier day than the 6th, perhaps the 5th, perhaps another day of January, and then use as much of that time as necessary. Your thoughts, Ms. Vendel, first?
Could I have a quick second to confer with my co-counsel in the room with me?
Certainly. If you're ready to respond, Mr. Fuller, or whoever's going to be lead counsel, feel free to weigh in and we'll get the state's response when they're ready. You are muted right now, Mr. Fuller.
Yeah, I'm trying to confer as well.
Very well. Take your time then.
Council. Sorry about that, Your Honor.
Yeah, Your Honor, one thought we had, so, we think that might be a good idea, given the volume of motions that have been filed in the case, as well as the exhibit objections. But perhaps what we could do is, instead of starting earlier, would it be possible to reserve the 9th of January as a possible spillover date instead of starting earlier? That might work. I don't know if the court has availability for that. And I'm, of course, I'll defer to opposing counsel on that too.
I was deliberately trying to avoid getting closer to the start of evidence.
I was going to, I guess, agree with Ms. Findell on that if we could do the 9th, but if at all possible, just given all the other preparations as well, if necessary.
Well, there's no reason I can't accommodate you on the 9th. That would mean working on Friday the 6th and Monday the 9th. Is that the preference of both sides?
Yes, Your Honor. Sorry.
Yeah, that's the state's preference as well.
So then, to the court coordinator there in Huntsville, she says that's okay. All right, so you can mark your calendars that we have pretrial hearings starting at 9:30 on Friday the 6th and continuing at 9:30 on the 9th. Now, I have an obligation on the afternoon of the 9th at 1:30, but at most, I guess it could put me out of operation for an hour.
And Your Honor, just a quick question for clarification. Are these in person or will these also be on Zoom?
Well, it's a good question, and I'm the court coordinator asked me that before we started today, and I told her I would ask you both what your preferences are.
Given that some of our team is not in the state of Texas yet and won't yet be in the state of Texas on that date, we would prefer Zoom if at all possible.
The state would prefer Zoom as well, Your Honor.
Zoom it will be. I will remember to send links.
Thank you.
Let me rephrase that. I will do my best to remember to send links. For January 6th and January 9th. All right, then. To the substance of what's before us this morning. Let me tell both sides that I have read your pleadings multiple times and attempted to do some research on my own. So I'm welcome to hear any oral presentation you want to make this morning, keeping in mind the preparation that I've just described to you. Mr. Campos, I believe it's the applicant's motion initially, so when you're ready, sir.
Thank you, Your Honor. I'll be as brief as I can. So the state's 15 subpoenas, Deuces Tecum, served in the last 2 weeks, and shortly before the court is to hold a long planned and critical series of hearings in this case. As the court is aware, demands from Mr. Falk, his experts, and his former and current counsel, in short, any and all documents and other materials relating to Mr. Falk's trial and post-conviction proceedings. On your face, Your Honor, we submit that the state subpoenas amount to gamesmanship designed to circumvent the court's prior discovery rulings in this case and harass and disrupt applicant, his witnesses, and his counsel on the eve of these forthcoming hearings. The subpoenas lack merit for a host of reasons, which I'll go over in a moment. I pause only to note 2 key points. As discussed in the motion, first, the state has served such improper subpoenas before, which Texas courts have quashed, and our motion attaches a transcript as the court is aware of such a hearing, and the same result should follow here. Second, the sweeping net cast by this last-minute fishing expedition by the state, should these subpoenas be enforced, we respectfully submit, Your Honor, that will most likely require a continuance of the upcoming hearings because we anticipate substantial document review and in-camera privilege review by the court of trial counsel files spanning some 15 years. We have approximately 87,000 documents in trial counsel files alone, not including the files accumulated during the post-conviction phase. The state's targeting of these files at this stage is not only unduly burdensome, it is needlessly time and resource wasting, given that the court has already ruled that the state is not entitled to these trial files. Now, if I may address the merits, the state opposition to applicant's motion actually concedes 5 critical arguments about these subpoenas that render them wholly invalid. First, the state concedes that the subpoenas served on Mr. Falk's experts request information that was previously adjudicated by the court and then provided to the state by the applicant. Second, the state concedes that the subpoenas served on Mr. Falk and his current and former counsel seek trial files that were previously denied to the state by this court. Third, the state concedes that these subpoenas were served beyond the court-ordered discovery schedule and deadlines. Fourth, Your Honor, the state concedes that those subpoenas that it served on 5 of Mr. Falk's out-of-state expert witnesses were improperly served in violation of the Texas Code of Criminal Procedure, Article 2428. Fifth, the state concedes that the subpoenas served on Mr. Falk's experts are overbroad. Now, the state disputes that these subpoenas seek trial files protected by either the work product doctrine and or attorney-client privilege. Yet, despite these 5 concessions, the state tries to justify its subpoenas with 6 arguments, all of which fail. Starting with the state's first argument, the state tries to justify its subpoenas by claiming that Texas Code of Criminal Procedure, Article 2402, entitles the state to demand that Mr. Falk, his experts, and his current and former counsel bring all the subpoenaed documents to court for potential use as evidence, even though the state, 1, helped create a robust discovery schedule to promote judicial efficiency, and 2, pursuant to that schedule, the state already discovered the documents which it was entitled to discover, as determined by the court's prior adjudication of the state's 2 motions to compel. So the state is effectively arguing now that Article 2402 grants the state the authority to simply reset the court's prior discovery rulings and serve subpoenas regarding previously settled issues. That is unreasonable. Such duplicativeness, authority over the court, and waste cannot be the rule. The second of the 6 justifications, the state tries to justify its subpoenas by asserting that applicant's motion to quash conceded the materiality of all subpoenaed documents. Applicant did no such thing, as his motion argues that the subpoenas are sweeping and overbroad, and that as a threshold matter, the state's rights to the subpoenaed documents have already been settled, with the state having received all documents to which it is entitled. Third, the state tries to justify its subpoenas by claiming that the state is entitled to receive counsel and Mr. Falk's trial files pursuant to the exact same waiver of privilege arguments that the state made in its failed April 8th, 2022 motion to compel, which motion the court rejected. The state is now wasting time recycling those failed arguments. Specifically, the state, Your Honor, invents out of whole cloth the legal position that Mr. Falk's claims against the state's conduct can be interpreted to amount to claims against himself for ineffective assistance of his own pro se counsel, and that therefore waive all of his and his counsel's privileges, entitling the states to those underlying trial documents. The state's position is incredibly novel, to say the least. The state has never offered any authority stating this position. In fact, the opposition at page 22 on Mr. Falk's purported waiver of privilege quotes a case named Ginsburg from the Texas Supreme Court in 1985. And the state's discussion of that case leaves out the fact that Ginsburg at 108 goes on to explain that this holding, however, should not be construed as granting license to litigants to engage in fishing expeditions into privileged matters. And that's exactly the state's position here, an unnecessary fishing expedition. The Texas Code of Criminal Procedure, Article 46B provides that the state may have its expert assess Mr. Falk's competency. Indeed, the state has availed itself of this pretrial procedure. That is the remedy here for the state to address Mr. Falk's state of mind and competency. Fourth, the state tries to justify its subpoenas by arguing that some of the, quote, applicant's witnesses are not testifying merely to things they have personal knowledge of, but are offering improper layperson opinion, speculation, and quasi-expertise to cast aspersions on the state 5 years ago, end quote. This argument clearly lacks merit. The state can object to any such purportedly improper testimony. It does not require subpoenas to resolve such objections. Fifth, Your Honor, the state tries to justify its subpoenas over broadness as necessary, stating that the, quote, the state subpoenas directed at applicants' expert witnesses simply ask that the experts bring all materials with them in case there are additional materials they have reviewed or produced that will not have been provided to the state by the time they testify, end quote. This argument amounts to an admission that instead of issuing targeted requests, the subpoenas are overbroad, which is an abuse of the procedure. Finally, Your Honor, for the state's sixth argument, the state admits that the subpoenas served on the 5 out-of-state experts were improper and in violation of Article 2428. Nonetheless, the state claims it was entitled to improperly issue these subpoenas, quote, only to remind the experts of their court-ordered obligations and to ensure the complete disclosure of materials to which the state is entitled, end quote. The state then adds a concession that, quote, the state does not oppose the quashing of those experts' subpoenas so long as the court enters an order requiring applicants to continuously comply with his discovery obligations, end quote. Your Honor, this is absurd. The state knows that subpoenas are not reminders. The court need not issue preemptive orders reminding people of ongoing obligations. The state is knowingly issuing, as it did in the other case we attached to the motion, the state is knowingly issuing defective, abusive subpoenas and forcing applicant, witnesses, and now the court to address them. So, Your Honor, for all these reasons, we respectfully submit that these subpoenas should be quashed. Thank you.
Ms. Bendel.
Yes, Your Honor. What applicant characterizes as confessions are mostly just the facts of the case. For example, yes, it is true that the expert witnesses and the state's subpoenas against the expert witnesses ask for materials that have been already ordered to be produced by this court. However, as noted in the state's response, applicant in this case repeatedly failed to comply with those discovery obligations over spans of months leading up to this case. And as noted in his recently filed exhibit list, he clearly intends to either provide or allow the experts to create new materials prior to the hearing, and the state is merely making sure that applicant continues to comply with its discovery obligations. The other concession was that the trial court has previously provided, or that this court has previously provided the state with those expert materials. And again, that's true. It's not a legal concession. It is just what's happened in this case. However, the concession that is beyond discovery deadlines, the state disagrees with. Again, as noted in the motion, this is not a discovery motion. We did seek discovery and we were denied. As we noted in those motions, both for the expert materials as well as for the trial counsel files, there always existed a subpoena power that we could bring these witnesses, or we could have these witnesses bring the materials with them to the hearing. For example, applicant's argument that, that if the state can just object to inadmissible testimony, that's true. However, if an objection is overruled and those witnesses are permitted to testify to the rank speculation contained within the affidavits that they've already written, then the state would be deprived of an opportunity to test any of those assertions if it's not provided with the materials. And the only way we can ensure that the materials are there was via a subpoena. Similarly, yes, the state has acknowledged that the out-of-state subpoenas were not properly perfected under the Code of Criminal Procedure. But again, the state also acknowledges, as applicant must, that these experts are already under court-ordered obligations. And as to it being overbroad on the experts, it is not, because that's actually already what this court has granted. As to the trial counsel files, the thrust and the main point of the argument that applicant conveniently ignored during his argument was that his attorneys and his witnesses that are testifying at this hearing have already explicitly signed waivers of privilege. Ms. Baker, who was one of applicant's standby counsel during the second trial, says in her affidavit the following: as required by Rule 1.05, the Texas Rules of Disciplinary Conduct, after consultation, Mr. Falk consented to my disclosure of the below confidential information I acquired during the course of my representation of Mr. Falk. Additionally, in response to a general waiver permitting the disclosure of confidential information signed by Mr. Falk and provided to her by post-conviction counsel, I told post-conviction counsel the information contained in this affidavit. To argue now that any of the materials, conversations, work product, mental impressions that are contained within any of the numerous witness affidavits that have already been filed in this case are privileged is the epitome of using privilege as a sword and a shield. These attorneys already acknowledge that they have waived privilege. Applicant cannot continue to hide behind that. And while it is true that the state mentioned in its brief the argument that the court previously presumably rejected, as opposed when it comes to extending ineffective assistance of trial counsel claims to the circumstances of this case, the thrust of the state's argument was the explicit waiver of counsel that has, or of the attorney-client privilege that has already occurred in this case. It is in writing, and at the very least, the court should ask applicant to produce the waivers that each of these attorneys have already signed in order to discuss conversations between them and Falk, to discuss their mental impressions of their investigation, to speculate as to his desires and his feelings and his behavior in court. Those are all necessarily information and conversations and communications gained during their representation of a client. They do not get to come into court, raise those allegations on the stand, and then shield any information that would support or undermine those assertions from the state. To be more specific, the state will provide several examples. Catherine Scardino, one of applicant's trial attorneys at the second trial, who was later standby counsel, discusses the investigative steps that they took. This is information that the state generally never obtains unless there is an ineffective assistance of trial counsel claim, which, as applicant notes, there is not. They state how they were reviewing the transcript, how they asked to inspect the truck, and that they believe that information was good for them for cross-examination of the state's witnesses in case. Similarly, Scardino also avers about conversations and statements that applicant made to them during the course of their representation, including that he told them he wanted to represent himself, but that he only agreed to let them proceed with jury selection that morning. Also, that he did not want to drag the Canfields through another lengthy trial, which goes directly to applicants' claims that insinuate that the only reason applicant pled guilty and the only reason applicant waived counsel is because of the state and the state's manipulation, coercion, duress, or any number of other conspiracy theories applicant is currently putting before this court. The applicant's response earlier about competency and experts, that is only one of the claims raised here. It is true he has an incompetent to plead guilty and incompetent to waive counsel. And it is true that the state has been granted an opportunity to examine him in order to rebut that. But those are not the only claims before the court. This court has also designated other issues, including that the state manipulated applicant so that he would waive his right to counsel. Those are not proper materials for an expert opinion. Those are factual questions that only one person can truly answer, and that's Mr. Falk, which is why the state is asking for materials directly from him, especially to the extent he would have contemporaneous materials addressing that question. And even though only one person can answer it, applicant reports that at least several of his trial attorneys can answer that as well, whether that's based on personal knowledge, speculation, or just hearsay. The state must be entitled to see documents that would undermine or disprove applicant's case. It is applicant's burden. He came to this court with unprecedented claims, attempting to convert what would normally have been ineffective assistance of counsel claims and foist it onto the state. These are factual assertions that the state must be able to test if applicant is going to put these witnesses on the stand. If he wants to shield attorney-client privilege and he wants to shield attorney work product, then he should not be calling 7 of his prior attorneys as witnesses on the stand to testify about everything they learned and thought about Mr. Falk during their representation of him.
I take it you're at a stopping place there.
Yes, Your Honor.
Mr. Campos, do you have a response?
Yes, Your Honor. As to the state's charge that applicant failed to comply with the expert discovery obligations, this is a misdirection. The state is ordering it that way because it doesn't want to put those facts in the proper order, that the applicant was failing to comply, and then the court ordered the compliance and the applicant complied, and the state does not dispute that the applicant complied. Regarding the discovery deadline, the scheduling order that was adopted in this case was based on civil procedures, which contain more detail than the relatively more bare discovery rules afforded under the criminal procedure rules, which would obviate the need for subpoenas. That was the entire purpose of streamlining the discovery process to make it more judicially efficient. So for the state to now claim that it gets to use all of those robust discovery measures and then use them again, regardless of the outcome of its motions to compel, is just simply overriding the court's authority. That is what the state is trying to do. As to the argument that the attorney Baker provided a confidential general waiver, this is also misdirection. That waiver, it presents a strong example of the state attempting to show waiver of privilege where there can be none, because the general waiver at issue in that quote amounts to a routine waiver granted by Mr. Falk so that his former trial counsel could speak about his case with his new appellate counsel and get them up to speed on his case as agents of Mr. Falk. It did not in any way open up Mr. Falk's privileges to his legal adversary, the state. As to the bullet points contained in the state's opposition at pages 19 through 21, containing examples of what the state claims are waivers of Mr. Falk's privileged information, in fact, these bullets describe only non-privileged, generic, and or factual information, almost all of which is actually on the trial record. And I mean, I could go through all of them and provide examples from the trial record discussing and showing that. I'm not sure we have the time for that. Would you like, Your Honor, would you like me to go through a few of them?
It's your choice.
All right. So, Miss, the state focused on the first bullet point on pages 19 that spill into page 20, discussing where Scaradino avers that they started their investigation into the offense from scratch, including, quote, reviewing the transcript from applicant's first trial, quote, asking to inspect the truck and doing a test with the truck, which gave them good cross-examination material in arguments against the state's theory at guilt. Then the opposition state that Baker similarly avers that they requested to inspect the vehicle, which in the defense's view was relevant because the state alleged that Martin intentionally drove the vehicle in the victim's horse at a high rate of speed. The state then concludes this reveals counsel's mental processes, including their strategic investigative decisions about applicant's case, such as typically the undiscoverable work product. We dispute that entirely. The statement started their investigation, the lawyer started their investigation into the offense from scratch is not a revelation of strategy. And the statement revealing the transcript from applicant's first trial, the fact that they revealed the transcript from the first trial to understand it, is not a revelation of strategy. The statement asking to inspect the truck and doing a test with the truck, the state was well aware of this because the applicant's attorneys had to request to inspect the truck, had to make these requests of the state. The statement gave them good cross-examination material and arguments against the state's theory. This is too vague to be a waiver. There's no disclosure of any specific facts or strategic conclusions. And then Baker similarly averring that they inspected the vehicle and that the vehicle was relevant to the incident because Martin intentionally drove the vehicle at the victim's horse at a high rate of speed. There is no dispute that the vehicle is relevant. It's the center of Mr. Falk's case. So again, there's no waiver here. There's no dispute of its relevance. The state conducts alleges a lot of these misdirections throughout these bullet points as to very generic material that it wants to claim is privileged. And again, it made not as detailed, but it made these same arguments in its motion to compel. The trial counsel files in April of 2022, and those arguments failed. The state at that time said, we want to test these lawyers' affidavits and they're alleging facts that support Mr. Falk's claims, and so we want all these files. It was the same. It didn't provide all of these details, but it was the same exact argument based on waiver of privilege, and it was rejected then and should be rejected now.
Your Honor, may I respond?
Of course.
Applicant makes averments that the waiver that Baker refers to in her affidavit was simply a waiver between former counsel to current counsel. That is not what she says in her declaration. She says that that Mr. Falk consented to disclosure of the information in the affidavit, and the information that she provided in the affidavit about information she acquired during the course of representation of Mr. Falk. The information in the affidavit is what was confidential. The conversations she is relaying are what was confidential. And even if applicant were correct that everything in there is just merely part of the open record and on the transcript, then frankly, what is the point of calling these witnesses in the first place? They offer nothing more, apparently, than what is already available on the transcript. That can't be the case, or they wouldn't have signed significant pages of affidavits discussing information they gleaned during the course of their representation. And I don't think it's worth the court's time to get into a tit for tat about every single thing they discuss in the affidavit. But by way of example, there's far more than what applicant is suggesting. They discuss conversations they had with the family members after the state's investigation to Tennessee. They discuss specific behaviors by applicant when they informed him about their intent to call and present and investigate his family members in mitigation. There's no information about that on the record at all. Additionally, I'm looking at other examples on here, but there's significantly more conversation about what Scardino and Baker and his former trial attorneys from the 2012 trial talked to Mr. Falk about with regard to his waiver of counsel. It was not really known on the record that Mrs. Esparza, Michelle Esparza from the first trial, had a significant conversation with Mr. Falk about not waiving his counsel. That is information that's also contained in an affidavit, and she was not even representing him at the time. She went there at perhaps defense counsel's request. It is unclear, but that is why we need that information from the trial counsel files. If there are communications in which current trial counsel was strategizing about how to undermine the waiver of counsel, then that is information we need, particularly where they're casting blame solely on the state. On top of that, and going back to this discovery scheduling order, again, the state was clear in its proposition about what the scheduling order should look like, that the discovery deadlines were there for judicial efficiency. And while this court denied that, that didn't mean that the state was hamstrung from requiring these witnesses to bring relevant documents with them to the court. Additionally, applicants charge that we don't dispute that he complied with it or trying to hide the fact of his failure to comply with it in the first place. Certainly, we might dispute that. For example, Dr. Coopers, one of his expert witnesses, interviewed applicant over the phone in 2020. Prior to the filing of the application. We were not provided any notes by Dr. Coopers from that evaluation. Possibly he doesn't have it, but again, that's information we intend to ask these witnesses on the stand. Also, applicant has repeatedly made assertions that basically if they don't have it in their possession, they can't be forced to turn it over even if the experts do. That is precisely why why these experts must bring these materials to the hearing. And again, if they're going to make assertions about what the waiver is, especially with regard to Ms. Baker's statements in her declaration, at the very least, they should be required to prove what those waivers contain. Never mind the content of the affidavits themselves, which definitely do go to conversations that are not all apparent from the record. And again, if they were, there would be absolutely no point in putting these witnesses on the stand. For those reasons, the state continues to request that the court compel these witnesses to bring the documents that are narrowed in the state's response with them to the hearing.
So brainstorm with me a moment what this would look like. On the day of trial or during the course of trial. The subpoenas on their face require that each of the named witnesses produce all of the named or described documents on the morning of January 11th. Leaving aside for a moment that could be staggered by some court manipulation of the reporting date. Imagine that the first witness comes before the court on the morning of January the 11th with his banker's box full of papers. What becomes of those papers? This is a question to the state. Do I order him to put them on your counsel table for you to take away? Do I order him to place them in the clerk's office for their safekeeping? Do I order him to hand to the bailiff so the bailiff can take them out and place them in my motor vehicle to drive around with? not to be absurd about this, but there is a practical issue about who has custody of these papers and who has access to them and when. I have to confess to you that I'm troubled. Shifting gears a moment now. By the state's invitation in the subpoena for them to comply with it by sending all these documents to your sergeant, somebody whose name I forget right now. But leaving that aside a moment, what is your vision, Ms. Vindell, of the practical day-to-day handling of these documents that you would have me order the witnesses to come to court with?
Yes, Your Honor. As to the court's last question about compliance prior to the hearing, that was just listed as an alternative, and especially with regard to the expert witnesses who are already under discovery obligation, if they wanted to continue complying by giving us additional materials they provided, they could, but it was not a requirement and it was primarily returnable at the hearing. But with regard to the court's question about the practicality of the files, the states would envision this would be similar to what happens when applicant is ordered to turn over trial counsel files. They do not bring all 1,000 documents with them to court. The court finds that privilege has been waived as to specific areas or assertions or the claims that have been raised. And then it is on those witnesses or counsel to make the determination about which documents they think are responsive. If they believe there are documents that are in fact privileged despite the court's order of waiver, they don't turn those documents over to the state. What they would do is give the state a privilege log, at which point the state could specifically request in-camera review of those documents. So in the state's vision, these documents would stay with the witnesses and or with applicant's current counsel, unless the court has entered a waiver about those particular documents, in which case they would provide those documents to us. If there's other privilege assertions they want to make beyond the waiver the court finds, then they would do so via a privilege log and provide the log to the state, at which point we could identify specific documents we would like the court to review in camera.
Okay, Mr. Campos, do you have any response to that?
My only response, Your Honor, is goes back to what I suggested earlier, that this process will take a long time given the volume of files and require a continuance. And again, I just raised the issue that the state has been trying for a long time to obtain these files and failed. And now it's found a new way to try.
Okay, I'm ready to announce a ruling if there's nothing else. Hearing nothing, then the motion to quash the subpoenas is granted in all respects. Now, that would make moot, I think, the state's request that I enforce the subpoenas. Is there anything else to be discussed this morning?
Nothing further from the state, Your Honor.
Nothing from applicants, Your Honor.
All right. I want us to make as smooth a landing as we possibly can on the morning of the 11th when we start taking evidence. Is there still some issue about the the presentation of the state's witness, Ms. Starnes, that I need to resolve earlier rather than later?
Yeah, I think as we stated in the email sort of back and forth with the court a couple weeks ago, I guess that was, we just don't seem to understand why Ms. Starnes has to be called out of order on the 11th if, it's not even clear to us when she will be leaving the country, if she'll still be here. That's never been sort of, nothing's been said about that, whether she could be called, at the appropriate time or not, and why she needs to be called out of order on the 11th. If she's going to be here, if she's going to be in the country. I mean, and there's a chance, if she is called out of order prior to our presentation, that she'll need to be called again to rebut something. So why not call her, during the state's case?
I'm sorry to spring that on everybody, perhaps without any preparation. Ms. Vendel, can you update us though?
Well, yes, Your Honor. Applicant's assertion that there's never been information about when she's leaving is an inaccuracy based on the state's immediate response to applicant's last request. Ms. Starnes, if I can pull up a calendar really quickly, is leaving the country January 26th, which is prior to the end of the evidentiary hearing. Moreover, she is traveling to get to the point at which she's leaving because there is a lot of, she's moving, Your Honor. This is not a vacation. She's uprooting her entire life and getting to this under her visa obligations. And she is traveling for a full week prior to that. She also has medical procedures on January 19th, and I believe the 20th, though I'm not certain about that. And applicant has 23 witnesses, including 7 expert witnesses. I don't think he can make any promises about when the state's case will start such that we can squeeze her in on the 18th of January, for example. Never mind that obviously would be very difficult for her. It was this back and forth and this uncertainty that the court entered its scheduling order to basically make this a binary option rather than get into the back and forth exactly about when she's available, what she has going on, what's preceding her departure. And that is why the scheduling order said, if she is here on that day, she will go on January 11th.
And that, that just to respond, and that concession was made when, it was like, it was sort of up in the air of, oh, she could be gone, at any point before the hearing starts, or, it's a possibility that she'll still be here beginning of January. I just don't understand if she is going to be in the country. Presumably she would have Zoom access too, if she's still going to be in the country. Why she needs to be called out of order prior to presentation of our case, and prior to the presentation of when the state would get to present their case, as she will be their witness.
Your Honor, again.
I will allow her to testify on January the 11th. I cannot imagine how the applicant is harmed in any way by the state essentially disclosing its defense with its first witness. And I recognize that there's every likelihood that she'll ask to be, the state will recall her later if she is at all available. But they can't guarantee that and that she will be available, nor can anyone else. So I will allow them the courtesy that judicial discretion allows of presenting her first. I'm sure it would be their preference to call her last or after the applicant had presented its evidence so that she'd have the benefit of all of that minutia. All right. Anything else that you can think of that you would like to get resolved today? If you can't think of anything, I'm more than happy to convene another hearing with you. And by the way, let me say that pursuant to Supreme Court of Texas instructions, this hearing has been live streamed on my YouTube channel. And it's also been recorded. And if anyone needs access to it, I'm happy to make that available to you. It'll take a little bit of technical work on my part to give you a usable link to the recording. I doubt that anything in it that's necessary for you to look at, but I'm just making you aware of it. Anything else this morning?
Nothing from the state, Your Honor.
And I wish all of you a happy New Year's celebration if you insist on having one. Good day.